Welcome back to Legal Stories. On today's episode, we look at the case of Nkhata versus Nkhata, decided on 28 November 2017 by the Supreme Court of Zambia. If you followed our previous video on Aggrey Chisanga versus Grace Samasumo, you will remember the high conflict over a house in Mainwood, Lusaka. Grace bought the land and built the house to window level before marriage. After they wed, Aggrey took out a 300,000 loan to help complete it. When they divorced, the local court ordered an automatic 50-50 split. The subordinate court changed this to a random 20% share for Aggrey. But on appeal, the High Court set aside the 20% and ordered the registrar to conduct a precise math-based inquiry to value their exact contributions. Why did the High Court refuse to just pick a percentage? The answer lies in a foundational case decided 9 years earlier by the Supreme Court of Zambia, Matthews C. Nkhata versus Esther Dolly Mwenda Nkhata. Let's look at the Nkhata case to see how it shaped Aggrey and Grace's case. Matthews, a driver, and Esther, a nurse, married in 2006. Unfortunately, the marriage broke down and they divorced after living together for about 4 years. Esther asked the court to divide their family assets, which she claimed included a second house built in Mutendere East, Lusaka, a Canter light truck, and monthly child maintenance. Matthews fought back with several arguments. He claimed he did not own the property. He argued the land belonged to his late father and that his siblings had built the houses before his marriage. He argued the house was built on an illegal settlement with no formal title documents. He also claimed the truck belonged to third parties and that he only possessed it because he worked as a driver and mechanic. The High Court disagreed with Matthews regarding the house and the truck. It found that the second house was completed during the subsistence of the marriage, making it matrimonial property. The court ordered it to be shared equally, 50-50. A sale agreement showed the Canter truck had been sold directly to Matthews during the marriage. It was also ordered to be shared equally. Matthews was also ordered to pay 300 kwacha monthly child maintenance and school fees. Matthews appealed to the Supreme Court. While the Supreme Court agreed that the High Court judge made a technical mistake by dismissing his illegal settlement argument as an afterthought, they concluded this did not change the overall justice of the case. The Supreme Court upheld the High Court's orders, dismissing Matthews' appeal. When the judge sat down to decide the Chisanga case in 2026, she relied heavily on the principles laid down by the Supreme Court in the Nkhata case. Here are 3 major legal principles connecting these two cases. Number 1. In the Nkhata case, the Supreme Court famously rejected what they called the 50-50 dogma. They declared, a marriage is not and should never be regarded as the reason for equal sharing of matrimonial property. The court explained that equal rights under the law do not automatically translate to equal portions of property. Instead, property adjustment must be based on fairness and actual contributions. Number 2, contributions can be in kind. Both cases highlight that a spouse does not always need to produce receipts to claim a share of a matrimonial home. In both Nkhata and Chisanga, the courts emphasized that non-financial contributions, such as looking after the household and caring for the family, relieve the other spouse of domestic burdens and entitle them to a beneficial interest in the family assets. Number 3, in Nkhata, the house was completed entirely during the marriage, and because the husband did not dispute the wife's contributions, a 50-50 split was upheld as fair. In Chisanga, the property was a premarital asset brought in by the wife and completed during the marriage. Because Nkhata dictates that property must be divided according to contribution, the High Court ruled that a judge cannot simply guess an arbitrary percentage without clear calculations. Because the evidence on record could not precisely show the value of Grace's premarital construction versus the exact value added by Aggrey's loan and materials, the High Court set aside the 20% award and sent the matter back to the registrar registrar for a formal valuation. Thank you for joining us on this episode on Legal Stories. We hope you found this breakdown helpful. Please remember to follow and subscribe to our YouTube channel.